right, here we are back. We've just done the citation and the fact section, and now we're going to actually talk about the issue. And we're actually going to do the issue and the decision all together because they really go together, and it's kind of silly because they're short. So let's talk about the issue. How do you find the issue in the case? Well, you looked at the facts. You know that what happened about the situation, and you know that the trial court said that they or ordered specific performance. They ordered London Bucket to go and do what they said they do, and to basically what they said, comply with the terms of the contract in their entirety. So that is what happened. So now, if you look back at the top, it says the basic contention of London Bucket is that the remedy of specific performance will not lie for this type of type of contract, for breach of this type of contract. Now, generally that gives us our, when we have that kind of contention, that's going to be the gist of the court case probably, unless of course the court says that's not really the issue. But in this case, if you start looking through it and if you've read through it, you know that what they're really trying to say is specific performance a remedy in this situation? They're asking for damages. It sounds like damages would make them whole. They could get the damages and pay for somebody else to come in and fix what was shoddy work, or what Stewart is arguing is that they could have them come back in and do the work. Okay, so the way I would put together the issue here is I would say something kind of like what it says at the beginning. Okay, so basically, let's make it in the form of a question. Is specific performance available as a remedy for a breach of a type of a contract that has to do with construction? And maybe we could be more specific, a construction contract in which the plaintiff is arguing shoddy workmanship, or you can put it in there the way that it wrote it. You can always use parts of the case as long as if you're quoting it right out of the case, put quotes around it, say it was from the case. If you want to go look up any of these cases to give you some information about briefing it, feel free to do that. I am always okay with with legal research. Make sure that your sources are reputable, accurate sources, and make sure that you cite correctly. I either take it out quote for quote and cite where you found it, or it's okay to change it and put it in your own words. If you change it entirely and put it in your own words, that's fine. But even just changing a few words out of a secondary source is still going to be plagiarism if you choose not to cite them. So please make sure you give credit where credit is due. So basically, that is going to be your issue. Is specific performance a remedy that could be used in this kind of case? Now, as you read on a little further, I think what you're going to find out is that perhaps it's a little more specific than that, because one of the things the court says is that there are these cases where specific performance was ordered, and that's what the judge relied on in the lower court case. But in both of those cases, there was no adequate remedy at law. So perhaps what we really need to say is specific performance a remedy if there is an adequate remedy at law? Because remember, the plaintiff can't get both damages and specific performance, because that would be double recovery on their part. So that is how I would coin the issue. You can coin it any way you want, as long as you kind of put it in your own words and have it, and that it is really what the case was decided. So here's the question. Ask that question, the issue, is specific performance available as a remedy in this kind of case? And what does the court decide? If you go down to the bottom, kind of the bottom, there's a sentence toward the bottom, and I'm going to hold up my copy of it which I've underlined. And here we go. It is the general rule that, I can't read it backwards, that contracts for building construction will not be specifically enforced because ordinarily damages are an adequate remedy, and in part because of the incapacity of the court to superintend the performance. So the answer is no. In this kind of case, specific performance is not an available remedy. So I underlined this in black. I underlined everything in black, but truly, when I find the law of the case, I underline it in black. So get your nifty little pen or highlighter or whatever. Highlighting in black isn't so good, but find a color that is this is the gist of the case. This is the law of the case. We call it black letter law. Just a funny coined phrase from lawyers to you. So I would say that that sentence for the end of the case is probably the crux of the case. So you've got your issue, you've got your decision, and we're done with that part. Click the next video and we'll talk about the reasons.